Hi everyone, welcome back to World Class Inventors. This is video number 26, and this is a continuation in part of what I put up in the prior video, video number 25. And I want to just drill down a little bit. I want to do a deeper dive on patent pending. So the topic I want to cover in a little greater detail is patent pending, constructive notice, and potential infringers. You see, you're granted patent pending by the PTO just by the very fact that you filed a provisional patent application, and then of course a non-provisional patent application as well. So once the office has received your application, you already have patent pending status. And that's very misleading, meaning some people might be led to believe that you have protection. And under the patent pending status, you really don't have any protection whatsoever. Patent pending means to other people who are out there that are working on a similar idea or come across your idea and might consider making a similar such product or filing a similar such patent application. It just means in actuality that you have an application in with the Patent and Trademark Office that's up for consideration. Doesn't mean that your application has been reviewed or your claims have been granted. So just understand that. Patent pending doesn't mean too much. Now, as I mentioned in the prior video, once you have patent pending out there and you filed your claims in the form of a non-provisional patent application, it allows you to go back to the point in which you filed this application and it's under consideration, that you can give constructive notice. It gives you a point in time for which you can go back to a would-be infringer and say, look, my patent application is in the office. These are my claims. You're in violation of my claims. And then it would have to be agreed upon by you, the infringer, your lawyer, their lawyer, as to when the constructive notice actually occurs. Now, that is a long shot because lawyers aren't usually going to agree about anything when it comes to intellectual property conflicts until the intellectual property conflict is brought into a court of law. And because these are federal questions, meaning patents and trademarks, this is a federal question. So we're talking about federal court here. We're talking about filing a full-blown lawsuit in federal court. Now, just because you've established your constructive notice, it doesn't mean too much because the other side is going to dismiss your attempt at thwarting them. They're going to say, well, we believe we're within our rights and we're going to continue to make this product. We believe that your patent is invalid, and we'll end up seeing you in court. That's typically what's going to happen. So constructive notice only really means something to the would-be patent filer, the person who has the patent in the office for examination, under the circumstances that their patent feud goes all the way to a federal court scenario. The other thing is, lawyers out there, the PTO especially, the invention help services companies, they're going to say, well, gee, if you have a patent pending status and you've established constructive notice, meaning your product was properly marked, it says patent pending, and it has the application number on there, that you're supposed to be able to enter into a constructive dialogue with a potential infringer. And out of this constructive dialogue, the potential infringer is going to settle with you. They're going to pay you a royalty rate and back royalties for infringing on your patent, or they're going to strike a license with you. That is total pie in the sky. They're going to do what I just said. They're going to tell you that your patent doesn't have any teeth, that it's invalid, that they're in the right, that they're going to see you in court. This is going to be a long drawn out affair. It's going to be 4 to 6 years of litigation. You're going to go through something that is very laborious, very tedious. You have to have a very good patent attorney and litigator. You have to have a judge that he or she knows what they're talking about, because now you're going to enter into something called claim construction. And that's where they're going to break down every single word in your claims. And they're going to fight about every single word in sequential order so that they can agree upon what your claims actually say. They really could care less about the king or the queen's English. This is going to be fought over. This costs a lot of time and money that most all of you don't have, unless I'm talking to a crowd that can withstand going through a protracted 4 or 5 year contest at roughly $400 to $600 an hour. I know we just got done watching the Johnny Depp trial on YouTube, and it was interesting and everything. But you'd really have to check out what he was paying per diem for his courtroom appearances of his 2 main attorneys and the support attorneys and the paralegals that were working in the background. It's a small king's ransom. I haven't done the math, but I'm sure that litigation, and it was a defamation litigation with lots and lots of hearsay, probably cost him in the neighborhood of $5 to $10 million conservatively. The purpose of this video series is to teach you about the fundamental aspects of what you're doing, to keep your head above water, to keep you out of litigation, and to basically pull back the reins on maybe a cavalier attitude that you might have taken on because of the false information you've been getting from various practitioners and the voices out there. Now, there's plenty of articles out there that will tell you that you should mark your product with patent pending designation, meaning it's done properly and you have your application number on there to thwart off would-be infringers. Well, I don't agree with that. I don't think you should be making any product whatsoever when your application is in the patent office. As I mentioned, and I'm beating a dead horse, my application for a tangle-free flag has been in the office for 18 months. I don't have an examiner. I don't have any patent pending rights at this moment. My claims are out there because that's what the office decided to do. My specification, my drawings, my know-how, everything that was supposed to be a secret recipe in my patent is out there before I've had any of my claims approved or disapproved. So for me to come up against an infringer at this moment and saying, hey, I have patent pending, that doesn't mean anything. That's not going to stop them in their tracks, Because in order for me to even begin constructive notice or to stop anybody in their tracks, I have to get my claims granted. And I don't know what examiner I'm going to have. I don't know what he or she is going to do with it. I don't know how they're going to play with the claims, how they're going to twist me and turn me and twist my arm to the point that I'm going to agree with the claims that they'll accept. See, they accept your claims. And it's typically not in the form in which you presented it to them. It's the form in which they want it presented. And this creates the back and forth between the inventor and the patent office. So in the end, you might be accepting a much more watered down version of your claims than you initially filed. So I don't think any of us who are small-time inventors or backyard inventors, and I'm putting myself in this category. Above all, I'm putting myself. Forget you, but me. I'm not going to be making any tangle-free flag. I'm not going to be trying to strike a license on a patent pending. I'm not doing anything until I get the grant. The grant is going to tell me whether I have a leg to stand on or any teeth in my claims. And that's really what I wanted to do in the first video, but it would have taken too much time and I thought I needed a follow-up. See, I want to do deeper dives on all this and I want to share with you what I know about, because I got into an intellectual property contest with the 18th largest corporation on God's green earth. And I got an education. And the pie in the sky that you're being fed, whether it be through the PTO or different lawyers you've talked to or different things you've seen on YouTube, it's totally different. Patent litigation is some of the most complex patent materials on earth. It's very time consuming. It's super expensive. And I just want to give you a heads up that don't have false expectations that you think you're protected when you're actually not. Okay, so I'll see you in the next video. Have a good day and God bless.